Продовжуємо роботу в українському кризовому медіа-центрі.
We continue our working day at Ukraine Crisis Media Center, and the next topic for today is devoted to Crimea. So we should speak about Crimea more. So time to correct mistakes and steps Ukraine should take towards Crimea. Our guests are Daria Svyrydova, Ukrainian Helsinki Human Rights Union expert, Olha Skrypnyk, chairman of the Crimean Human Rights Group, Tetiana Pechonchyk, head of the Human Rights Information Center, and will be joined by Yevhenia Andriyuk, the deputy coordinator of Crimea SOS Public Initiative. Welcome. Good afternoon, dear colleagues. Thank you very much for this attention to the topic. And I would like to remind that 1 month ago, the resolution was taken by UNO concerning Crimea, and this was done due to the report prepared by the mission on human rights of UNO that worked in the territory of Ukraine. This resolution is the provision of in the sphere of human rights in the Autonomous Republic of Crimea and in the city of Sevastopol and Ukraine. And there are grave violations in the occupied territories from the start of the occupation. The majority of these violations are connected with the illegal actions of the Russian Federation and also occupation authorities in this territory. And there are persecutions of Ukrainians and the Crimean Tatars and many other violations concerning jurisdiction and also forced citizenship, seizure of property, and other violations. At the same time, for the first time, UNO Assembly stated that what Ukraine is doing in relation to the citizens of Ukraine that live in Crimea, and it greeted the support of that Ukraine provides to the population that is in Crimea. So the control in Crimea is carried out by the Russian Federation, but Ukraine should not forget about its obligations and should provide support to the population of Crimea. And we greet the important steps made by Ukraine to support the residents of occupied territories, and this is the protection of rights of political prisoners and other important steps. Unfortunately, our work, the monitoring we carried out, and the legal work, the legal support we provide, services provided by our organizations, we see that there are a lot of gaps in the legislation of Ukraine that create systemic problems and violate the rights of the residents of the occupied territories and those who are IDPs, because some bodies of official bodies of Ukraine are inactive or not active enough. So we try to provide a message to the state, and we provided the recommendations to the report to the UNO, and there were recommendations what Ukraine should do to support IDPs and the residents of occupied territories, but unfortunately many problems remain unresolved, and today we would like to voice the information about the roadmap developed by our organizations concerning top steps that should be taken by Ukraine in order to meet the needs of the residents of Crimea and to implement its obligations concerning these residents, and to avoid discrimination concerning residents of Crimea and IDPs from Crimea. You may see the these 10 steps we've prepared on a chart, and today, together with our colleagues, we are going to speak about these 10 steps and why we chose them. So, first, what the residents of Crimea encounter with, despite all the risks and difficult situation, living under occupation, they stay in this territory and they do everything possible in order to have legal connections with Ukraine. And we would like to speak about the problems of recognition of the facts of death and birth in the occupied territories. And this is connected with the legal initiatives that are ongoing at the level of the Supreme Council of Ukraine concerning reintegration of the territories of the East, the reintegration of Donbas. And I will tell you later how this topic is connected with the reintegration of Donbas. And as of today, one of the main problems in Crimea, big difficulties in getting proper documents of Ukraine and concerning the facts of birth and death. And a big step was made by Ukraine towards Crimeans, and the current legislation was changed, and they established court procedure to identify these facts. But this court procedure does not properly resolve the issues of documenting. As of today, it doesn't meet the needs of the residents of Crimea and do not correspond those obligations undertaken by Ukraine. We believe that the courts now have functions that are not appropriate for them, and they replace some administrative procedure and they consider the documents that are issued by occupational authorities, and they take decisions based on these documents concerning this or that fact. So this was done in the framework of the procedures undertaken by state registry officers, and these procedures are connected with the material burden for the residents of Crimea and the participation of lawyers to prepare those documents for courts. And the courts consider the same documents. They should not be considered as evidence because the law on occupied territories does not allow to take into account the documents issued by occupational authorities in occupied territories. But in difficult situations, the courts consider these documents, and the courts replace this administrative procedure, and they issue the documents on death and birth of the citizens in the occupied territories for statistics. In order to understand the efficiency of the procedure, I would like to state several figures. In 2016, in the territory of Crimea, except Sevastopol, 22,000 children were born, and 28,000 people died. And in the court decision register, in the framework of our research, we found for the whole period of occupation only 5,000 decisions of identification of the facts of birth, and taking into account our data and according to information provided by the Ministry of Justice and provided by illegal power, so Ukraine have only 15% of the facts of birth, and So when Ukraine restores its control over these territories, so we can only imagine the number of people who won't have proper documents. So what our proposals we propose to the state is to establish the administrative procedure to provide documents on the facts of birth and death for the citizens of residents of the occupied territories. These are obligations that Ukraine undertook in the framework of the document that is the national strategy in the sphere of human rights for the period up to 2025, and its implementation and the strategy was adopted by the provision of the Cabinet of Ministers, and it says about the need of introduction of such administrative procedure, and the introduction of the administrative procedure is the recommendation of the Council of Europe concerning the protection of human rights, and yesterday they voted for the law on reintegration, and I do not want to go into detail, but I would like to say that in this law there is such a norm that gives instruction to recognize the documents issued by occupation authority in Donetsk and Lugansk regions concerning births and deaths in these occupied territories. So this administrative procedure will be established for residents of the occupied territories in the east, but won't be accessible for the Crimeans. And also one more vulnerable group Ukraine forgets about, and this group needs a proper status and they need proper documents. So this is about prisoners or people who serve sentences or served their sentences in the occupied territories. So this category of people, such people who serve their sentences in the occupied territories, they were released and they are deprived from any opportunity to recognize their status as people who served their sentences. Moreover, these people are deprived of social benefits, possibility of reintegration and socialization and other types of help that are provided by the state of Ukraine to people who served their sentences, because we do not recognize the fact that these persons served their sentences. And the draft law that was developed by the Cabinet of Ministers, unfortunately, in our opinion, have a number of threats and can lead to violations of human rights. And as of today, it is not registered, and in any case, this problem, as of today, remains unresolved, and there is no steps toward these people, and many of them, they massively, and our organizations know about it. We have a lot of addresses from uncontrolled territories. These people address Ukraine in order to recognize their status as those people who served their sentence there, who served their sentence in these territories. And also they want to return under control of Ukraine. And the second recommendation is connected with this. This is the requirement to state bodies of Ukraine, to the government of Ukraine, concerning the development of the mechanism of returning these people to the territory that is controlled by Ukraine. As of today, and in 4 years of occupation, 10 people were brought first to the territory of Russian Federation, and then they were handed over to the power of Ukraine. So these people, I do not want to comment on their situation now. And this problem remains unresolved, and they are deprived of opportunity to reconsider, considering their cases, the sentences that they got by Ukrainian courts in the territory of Crimea before occupation. But there is no such a mechanism, and this is our third recommendation. Ukraine should develop clear order of retaking the decisions concerning cases for people who continue to serve their sentences in the territory of Crimea or were brought to Russia illegally or have returned to the territory of Ukraine and they need urgent realization of their right to appeal their sentences. So these are two steps I wanted to say. And first of all, it relates to people who are in the occupied territories, and they wait for these two steps towards them. And I would like to give the floor to my colleague, Olha Skrypnyk, chairman of the Crimean Human Rights Group. I represent this organization for the 4th year. We document human rights abuses. We document military crimes in the territory of Crimea. And also, because of the actions of the Ukrainian power, we also carry out activities in order to help people, and our team, we are IDPs from Crimea. Also, we are helped by many people who stayed in Crimea, who help Ukraine, who support Ukraine and Crimea. That's why for them it is really important to get support from Ukraine. And by documenting human rights, we communicate with witnesses of the victims, and our friends and relatives stay in Crimea, and we know their situation. And they go to controlled territory of Ukraine, and here new problems arise, and also recommendations. We would like to voice those recommendations we represent here today with our colleagues. So one vulnerable group, these are activists, concerned people, those people who became victims of persecutions, and at the end of the year, our colleagues who are here today and other organizations, we sent to the bodies of power the documents concerning people, 50 people last year, 55 people were in prison, and new cases appear, and people are sent to jail, and Vladimir Balakh got a second sentence, and after he was sentenced, his mother provided comments to journalists, and she said that in 3 years of fighting for Ukrainian flag in Crimea, they didn't get any help from Ukraine. Yes, there was help from indifferent people, but not from the state. So if we people, the relatives of prisoners, they want this problem to be resolved, and there should be proper legislation to support political prisoners and the relatives of those people who are illegally held in Russia and serve sentences there. There are such initiatives now, but there is no political will to adopt such acts, and also Mr. Groisman have to sign the changes to the provision concerning the use of funds by the consulates. It is developed and it should be signed, and it will help people who serve their sentences illegally in the territory of Russian Federation to get help from Ukrainian state, but this is not signed. And also the draft law was developed by our organization, the organizations. We submitted changes to improve this draft law on support of families of political prisoners and people who are prosecuted on political grounds. So this year, we believe, should be started with introduction of such changes and provide real support to people who became the victims of persecution by Russian Federation in this conflict, because these people, they fight that Ukraine is in Crimea, in Donbass, but they do not have support of the state. And we demand from Ukraine to adopt these changes that will really help to these people and their families. And if we take Crimean cases against Crimean Tatars activists, Ukrainian activists on the whole, about 100 kids now are deprived of parents. Their parents are in detention facilities in Crimea or in Russian colonies, and these families, they do not get proper state support from Ukraine. And also the issues concerning the status we are speaking about for 4 years starting 2014, so this is non-resident status. I'm from Crimea and I'm a citizen of Ukraine, but I'm non-resident. I would like to bring an example how it works on practice. Recently, a person who was tortured by Russian authorities and served sentence in Russia, and this person served the illegal sentence in Russia, went back to Ukraine, registered as IDP, done everything that was needed, but this person needs money, and many people tried to help, and they started to send money to his private bank card, but the bank blocked this card because of his non-resident status, despite he has IDP card. So these people whose cards were blocked after even they changed their registration, they do not have a registration of Crimea, but they remain non-resident, and this is discrimination in banking services and other financial issues that now we have because of free economic zone Crimea, and this is absurd. What free zone can we have there if there is occupation? And this law continues, and non-resident status continues as well. And we believe that the law on the free economic zone should be cancelled, and there should be proper draft law that would regulate issues of Crimean occupation. But these changes should not we should be residents, and also we should take into account the issue of taxes, but this issue of non-residents should be resolved. And the problems about the crossing of administrative border, the crossing of checkpoint, and this is about evacuation of personal property. We had provision 1035 that limited bringing personal belongings, and the first point of this provision was cancelled, but people still face difficulties while trying to bring their things from Crimea. So the customs officer used the provisions of customs code and limit the crossing of people with their personal belongings. The acute problem is bringing domestic animals and to bring, for example, art or items or other things. So we should introduce appropriate changes in order that people could, simple people of Ukraine who live under occupation, they should have opportunity to freely bring their belongings out of Crimea. So we should increase the level of hygiene at the checkpoints and to do other important steps in order that our Ukrainians who travel from Crimea to Ukraine, they should see these checkpoints as open doors for them, not just like obstacles they should overcome. So this is what we've placed in our roadmap, and we recommend these actions to our state in order to be implemented. I give the floor to my colleague.
My name is Yevhenia Andriyuk. I represent Crimean Source organization. This is an NGO. For 4 years, we have been assisting the citizens of Ukraine who live in the occupied territories, and also we have been putting maximum efforts on the mainland Ukraine territory to provide assistance to IDPs from Crimea and to make return to Crimea faster. According to the legislation of Ukraine today, if a person moved from the Crimea to the mainland Ukraine as an IDP, request is sent to the pension fund of Russia, and only when the pension fund of Russia gives the answer to such request to Ukrainian pension fund, only when Russian Federation's pension fund says that they do not pay pension to this individual, then in 6 months period approximately, this IDP will be paid pension benefits in Ukraine. The individuals' personal data are reviewed first in Ukrainian pension bodies, and the requests are sent to the Russian Federation Fund. Maybe it seems that the situation is normal, but in the conditions of the armed conflict, we are disclosing the data, private data of IDPs to the bodies of the aggressor country. We do not know how this private details would be used further by this aggressor's country governmental bodies. They could be used against the family members of those people or for some other purposes which can influence negatively on the IDPs. So we call on our bureaucrats to stop these practices and to organize the other procedure, because it concerns not only pensioners but also other people whose private details are transferred. The second issue is issuing of passports. It is even more relevant now because of the introduction of ID cards and biometric passports, and those passport issuing is rather easy and positive for Ukrainians than the Crimean residents. They have procedures very complicated. So the procedure of identification, where the burden of proving his identity is now placed on the individuals. So during the period when ID cards are issued, the people should stay here in the mainland Ukraine, for example in Kherson or Kherson region. How a person can live for 2 months in Kherson region if the person is living in Crimea, it is not understandable. And the Migration Service has a list of documents rather narrow, and there are no established periods for the identification. We demand, we do not advise, we demand that the list of documents is rather wide, and also we should relieve the burden to prove the identity from the individual. This burden should be on the state bodies. Otherwise, within several next years, we will face a situation when we will have thousands of persons, citizens of Ukraine, lacking any documents of identity. And besides political prisoners who are subject to political and administrative persecutions, there are people who have been kidnapped by the governmental bodies of the Russian Federation, and we ask that the status and guarantees are fixed for the government to protect those abducted, those kidnapped persons. And we also hear many explanations why it is so. We understand these restrictions when we look onto the Crimea as onto the land, but the occupation concerns every person, every Crimean resident. It starts with communication with the frontier guard. When Ukrainian frontier guards, when they ask Russian Federation's passports from the Crimean residents, then our deoccupation process fails. We should do everything. Only when Ukraine does everything for Crimean citizens, then our deoccupation process would be successful. My name is Tetiana Pechonchyk. I am the representative of the Center of Information about Human Rights. I would like to finalize with three aspects: violation of the human rights by the Russian Federation's occupation. This is education, elections, and access to Crimea. As you know, IDPs from the temporarily occupied territory of Ukraine, like those from the occupied territories of Donbass, they cannot vote at the local elections. This is the discrimination fact, because people have been living for several years without the right to take part in elections at their local level, and there were several complaints communicated to the Ukrainian government by our center due to discrimination by the fact of being member of IDP groups. So we expect that the European Human Rights Court would issue resolution in these cases, but we want Ukraine to regulate these issues before the judgment would be issued by the European Human Rights Court. The next question is education issue. For students of schools and higher schools. It is only declarative in Crimea, despite of the positive decision to provide quotas for Crimean residents. The government did not pay attention to those problems connected with Crimean students of higher education institutions. They are deprived of their benefits and their rights for living in hostels. And there is also problem with free of charge comprehensive school education. Now it is only possible with the use of the procedure of distance learning, and also external studies procedure, and also the range of higher educational institution. The number of them is very limited. This is a kind of reservation, a ghetto. Children from Crimea, they are restricted in their right to equally select the higher education institution they want to enter, and the access of journalists to Crimea is restricted as well. As you know, foreign people such as advocates, human rights activists, and journalists whose presence in Crimea is very important. If they want to access Crimea from the mainland Ukraine and they have special permits for entering Crimean territory, the resolution number 367 of June 2015, it did not have any provision allowing foreign journalists and representatives to get access to Crimea. After we many times focused attention of the government on this resolution, it was amended 3 times, so these categories were added to the resolution that they can ask for the permit to enter Crimea. But the procedure, even after all these amendments entered, it is a real obstacle to access of human rights and advocacy missions and journalists from other countries in Crimea. This resolution is saying that such permits cannot be asked via diplomatic missions. Those individuals should enter Ukraine, get permits from relevant ministries, which may take 2 weeks or a month's time. Then they should go to the migration service and to fill questionnaires in Ukrainian. But we think that Ukraine should be interested, should be the first interested body in coverage of those developments in Crimea, because Ukraine can't protect itself, the rights of its citizens in other in the courts, in international courts or courts of other countries. But instead of that, we see very complicated bureaucratized procedure of access to Crimea. So we should state that most of visits of Russian lawyers to Crimea are conducted via violation of the legislation, and Ukrainian government has done nothing to simplify the access procedure to make it easier. It should be changed from the permitting one to the notifying procedure. So we hope Ukraine will simplify the procedure of access to Crimea. Finalizing our presentations, we ended the 2017 year with the greetings to the UN resolution of 19th December 2017, where it was recommended by the UN to do more efforts to maintain relations with the Crimea. We want 2018 to become the year when the Crimean citizens would be heard by Ukrainian government, and the steps would be made by Ukrainian government towards them. And we want the profile ministry on temporarily occupied territories and IDPs to find the platform to communicate their position to the public on the issues which we addressed today. And now we are starting the round of questions and answers. I have one specifying question. If you are analyzing what draft laws are being elaborated or regulations will they help to address those issues you mentioned to date, and which of them are most ready and could be submitted? The most close perspective which we see is the issue of support to the families of political prisoners and political prisoners themselves. The draft law has been registered with the Verkhovna Rada. We think it should be amended, but this draft law may soon become the real support to the families of political prisoners, because they need day-to-day support in their day-to-day lives, and the political prisoners themselves need Ukrainian support. If our parliament wants to do something, they vote for the law. This is the closest perspective. There are also initiatives to cancel the law on free economic zone. For the third year, these initiatives have been discussed, and we know the initiative of the government of Ukraine about the status of those people who are serving their sentence in the Crimean territory, or who have served their sentences in the territory of Crimea. It has passed the public consultations process, and it has been considered by the NGOs, but we do not know its fate. I'd like to add that last year, at the beginning of the year, the Ministry of Occupied Territories and IDPs, they adopted the action plan on improving the equipment of the checkpoints, but no positive changes happened. Although the action plan is available, maybe the problem is with the budget allocations to fund such improvements. And the governmental bodies, for some reasons, have not implemented this action plan. We are always responded that there is no political will, or there is no funds, or we are in the status of war. So, even in the conditions in which Ukraine lives today, having the problems related to the occupation and war, the amendments which we propose and the changes which we propose, they're absolutely realistic and could be implemented. Are there any questions? Good afternoon, my name is Garban Vladislav, public activist. Thank you for your work and for these presentations today. Nobody knows the needs of IDPs better than you. I have two questions, one about the procedure and second about the implementation of measures. The first question is whether any of them or any of your organization is a member of public councils which are listed on the first page of your appeal as a mechanism of control and encouragement of executive authorities via legal procedures. The second question. Our civil servants do not like to read much. I just want you to change your wording of your appeal a little bit. Just move the final provisions to the first page then the bureaucrats will easily see what you want from them. Thank you for your question and your proposal. As concerns public councils, I can say our Crimean human rights group, our experience of working with the Ministry of Informational Policy, we have been communicating with them and we had negative experience. I left from the public council at this Ministry of Information Policy. Now this ministry is more active, but those days it was not. We have many issues which are in the competence of the Migration Service, and we address the public council with this service so that they help to improve the situation with the migration issues. There are some positive experiences, positive cases. As concerning administrative boundary, the checkpoints, many issues are addressed in voluntary way. They should be resolved in general at the legislative level. We can wait for a long time for something from our state, so we should be more proactive. And the initiative was a work group at the Ombudsman office, Valeria Lutkovska's office, and my colleagues who are here today. Among the speakers, they are members of this work group, and we will develop the concept formulating the governmental fundamental principles as to the adherence to human rights, and the first steps to be made by the government towards IDPs who moved from the territory of Crimea. This is at the level of the work group today. The concept, I hope, soon will be presented. It concerns very many groups of the Ukrainian population, and we want the discussion to be as broad as possible. I would like to add that in these problems, the problems which we highlighted today, they are not new for the government. We have addressed the governmental bodies via different statements, via different declarations at the United Nations. Daria said that these issues were stated in the last resolution of the UN about the status of developments in Crimea and Sebastopol, and saying that it is very important to maintain relationship with citizens of Ukraine living in Crimea via our cooperation with the Ministry of Foreign Affairs, Ministry of Information Policy. These issues are known to international institutions, and the Council of Europe will address these issues next week. And political will should be present, it should be in place to resolve all these issues, and we place hopes, big hopes on mass media sources, because they may encourage the state bodies to resolve these issues. We not only criticize, we have proposals that have already been transferred by us to the governmental bodies. Our four organizations which are Ukrainian Helsinki Human Rights Union, Crimean Human Rights Group, Human Rights Information Center, and Crimean Source Public Initiative. We transfer today our statement and integrative roadmap to the Verkhovna Rada and international institutions, and we hope that our roadmap will help our government and our state to resolve the issue comprehensively. Yes, we should talk about Crimea, and we should support IDPs and Crimean residents. That's the end of the official part. Thank you.